Hello. What is the Spanish system of obligatory heirs, and what does it mean for me, an expat who's purchased a property in Spain moving forward? What does this system of obligatory heirs mean, and how will it affect me and my spouse? My name is Michael Davis. I'm a Spanish lawyer specialized in estate planning and probate for expats. We handle cases all over Spain. Okay. Now, the Spanish system of obligatory heirs scares some people when they find out about it. Basically, what it means is under the Spanish system, Spanish people cannot leave, for example, everything to their spouse in their will. There are limitations. Basically, they have to leave at least 2/3 of the estate down to their children. So when people hear about this in the first instance, they think, wow, I can't believe this. I've purchased this. I've, together with my wife, we've purchased this property down here in Estepona or wherever. And we don't even get on well with the kids, or we've got kids from other marriages. How can we avoid this? That this will be a disaster. Okay, it's very easy. So there's a thing called Directive 650/2012, which came into force in 2015. And basically, it allows you to make a Spanish will in which you choose your national law to determine how you're allowed to distribute your estate. So as long as you make the Spanish will and you expressly make the choice of law with the correct wording, which is conforming to Directive 650/2012, I expressly choose my national law, English law or Dutch law or whatever, to determine how I'm allowed to distribute my estate. Then you can go on and leave things in the same way that you do in your home country. So a typical case is English people that in the UK can do whatever they want and very often make mirrored wills with a second step down to kids. As long as you make the will in Spain and you make the choice of law, then you escape the Spanish system of obligatory heirs. Okay, so what happens if you don't make the choice of law on the Spanish will? Okay, well then what the directive says is that we will always end up, Spain will apply the law of the last residence. So where does the disaster come? Well, the disaster comes if you haven't made the choice of law, and when you pass away, you happen to be a resident of Spain. Because if you are a resident of Spain and you haven't made the choice of law, the Spanish system of obligatory heirs applies, and therefore you wouldn't be able to leave everything to your spouse, and the will will be partially as you won't achieve what you wanted with the will, which is leave everything to your spouse. So if at the time of death you haven't made the choice of law, the notary tries to find out where was this person resident. If you're a resident in the UK and you can prove that you weren't resident in Spain, that you were resident in the UK, in this case it's in England, then he will apply that law to determine how you're allowed to distribute your estate. We always recommend that you make the choice of law. Even if you're English, if you're English and you're going to remain resident in the UK, make the choice of law, because then nobody has to prove later on where you are resident. Now, something different is you may have a person from a country that has a system of obligatory heirs. For example, let's say you have a national of France, where there is also a system of obligatory heirs, and he has got assets in Spain. So what he wants, and he is resident in England. He resides in London. And what he wants to do is leave everything to his spouse because he doesn't get on well with his children from his previous marriage. Okay, so how does he achieve that? Well, he cannot make a choice of law because his national law is French law. It won't help him. If he was resident in Spain, a disaster, because the Spanish system of obligatory heirs would apply. But if he makes a will in Spain, does not make the choice of law, and when he passes away, he is at that time a resident in London, then of course, Directive 650/2012, it says to Spain that Spain will have to apply the law of the last residence. So if he makes a will leaving everything to his wife, even though he is French, as long as he's resident in the UK, in London, at the time of his death, Spain will accept that it's English law that applies to how he's allowed to distribute his estate. Okay, I hope this was clear. So if you need any more help on this, or need help with your will, or need us to have a look through your wills, your existing wills, to make sure that this is done correctly, give us a call. If you found the video useful, please hit the subscribe button, as it helps other clients find our videos. Thank you.